Welcome back. It's Tuesday, April the 15th, and you know what that means, TLR Tuesdays. I'm Mary Tipps, Executive Director of Texans for Lawsuit Reform, joined today by Lee Parsley, our President and General Counsel. Today we have a very special guest, Justice Dale Wainwright, and he's here to talk to us about nuclear verdicts and thermonuclear verdicts. Justice, tell us a little about yourself and why this concerns you.
Well, again, great to be here and join both of you. I think you're doing great work that's important for our civil justice system. My background is 37 years practicing law, 14 and a half of those years as a jurist, 3.5 of those years were as a civil district judge in Houston, and then I was elected to the Texas Supreme Court to an open seat in 2002 and reelected in 2008. Served a total of about 11 years on that court before I retired and returned to private practice.
Thank you for your service.
My pleasure. It was an honor. My background in nuclear and thermonuclear verdicts comes from study, but most importantly from being on the battlefield and dealing with these issues, both during trial and on appeal. A big part of my practice is commercial, but the personal injury docket has grown substantially. I've spoken around the country and done analysis of what's going on in Texas, and it was shocking when I first did the analysis and found that over the last 5 years alone, the top 10 personal injury verdicts in Texas have exceeded $12 billion.
Wow.
This is in a state that's had several decades of tort reform legislation, and still creatively the plaintiffs' bar has found a way to come back with a number of very unreasonable and excessive verdicts.
Are you finding that Texas is in a worse place in terms of the nuclear verdicts than other states? Have you looked at Texas comparatively?
I have, and there's also some studies that show that the last several years, Texas has not had, well, let me rephrase that. I have taken a look at that, but also seen some studies that show that no state has had more nuclear and thermonuclear verdicts the last several years than Texas. Again, shocking given a state with a conservative legislature and governor and years of tort reform legislation.
Right. So, we always want to make clear to the listeners out there that if you're injured, you're badly injured, you've got a right to go to court. You've got a right to a fair and efficient civil justice system and a award in your case that compensates you for the damages you've suffered, and the right to, in some circumstances, punish the defendant for anti-societal conduct. So no one disagrees with that. I don't think you do either.
That's correct. I'm not anti-plaintiff. My view is if the plaintiffs prove liability with appropriate evidence and prove damages, they're entitled to reasonable damages. And if certain conduct was involved in the accident, then punitive damages may be applicable. But excessive and unreasonable damages hurt everybody, not just the employers, but it raises insurance rates for everybody. It makes things more costly, and the justice system just seems to be unfair to a lot of people when you see awards that essentially are like an award of play money, playing a Monopoly game. Some of it's just really incredible.
Well, Justice, can you give us a couple of examples that come to mind?
I can. Of those 10 largest verdicts, I was honored to get the call to handle 4 of them, partially during trial and on appeal. They range from $500 million up to $7.4 billion in those 4. I won't mention names of companies, but one in particular was an off-duty technician who had the day before this incident provided some internet service for a customer. Somehow they exchanged cell phone numbers. The next day they agreed that he would come to her house and do some service off the books. Basically both of them understood they were stealing from the company. Something happened incredible. He ended up murdering her.
Oh, Lord.
The finding was that the company was responsible for the actions of an off-duty employee. Of course, the company had no control during the day off. The employee had been to casino gambling that same day, in fact, but something happened at the house, and he murdered her, and all the fault was put on the company. And then in a strategy that was very interesting, during trial, of course, everyone was upset at the off-duty employee. He was serving a life sentence actually in prison and did not show up at the trial. But after the liability findings and the predicates for punitive damages, malice, gross negligence, or fraud, after those findings, then the individual who actually committed the heinous crime was non-suited from the case. So in the punitive damages phase, the jury was looking at one company and one blank, after being very upset, like we all were, at what the employee had done. And so the company arguably was hit with much more of the angst and the disgust by the jury than should have,
Right.
if they even should have been found liable in the first place. Just an interesting strategy. I hadn't seen that before.
What's the answer in the big picture? How do Texas get back to where we've got a civil justice system that's reasonably predictable and fair? And what do we do about this problem?
Well, it takes a combination of a number of efforts being effective.
Right.
One is we've got to have judges who are experienced and believe in fairness and aren't leaning one way or the other. Okay? Right. You've got to apply the law as written and follow binding precedent. Okay?
And your experience is that's not happening every day in Texas right now?
It's not happening every day in Texas. That's a good way to put it right now. So having an experienced and reasonable judiciary is important. The Texas Supreme Court weighs in on issues through its discretionary review that are important to the jurisprudence. Soft damages had not been an issue in Texas for 20 years till 2 summers ago when the Supreme Court issued the Chohan opinion, which was a plurality. But in the intervening 20 years, hadn't been a big issue. And the court's docket is based upon the court granting cases that raised issues that are important to Texas at the time. Well, soft damages or non-economic damages are a big issue now. The court started providing guidance now with that opinion, and as more of those types of issues involving soft damages trickle up, they will have an opportunity to provide more guidance. So that's going to be important. Legislation that provides reasonable and fair and just basis for liability and for damage amounts is important as well. That way it provides some consistency across the state. We've all talked about and heard how with 14 courts of appeals, more than in the entire federal system in the United States, the courts can go different directions and the law can be unclear sometimes. Well, with legislation, then all the courts are supposed to follow that. So it provides predictability and consistency across the state as well.
So we're working on that.
Yeah.
I understand.
Music to our ears.
So bringing all that together is what's going to be important, and that's going to require the public to get involved. It's going to require plaintiffs to get involved, defendants to get involved, big companies, small companies, every industry to get involved to ensure that we have a fair and just system.
Well, yes, absolutely. So our bill that we're working this session is Senate Bill 30. And it does some things that you might recognize, I suppose. We're trying to give jurors better data to make decisions about non-economic damages. For example, they don't always get a definition of pain and suffering. Some trial courts will give them a definition, many won't. Mental anguish the same way. Some trial courts will give the jury a definition of mental anguish, many won't. So statutorily, we're just asking that the trial courts of Texas give a statutorily defined definition for pain and suffering and mental anguish. We think, there's just transparency. Give the jury some guidance so they know how to make a decision. We've looked at other states about how you ask about to award damages. And some states just say, award a dollar amount for pain and suffering, mental anguish, and all other forms of non-economic damages in a single blank. Just fill in this one blank. Some states like Texas have multiple blanks on the jury charge where you fill in past pain and suffering, future pain and suffering, past mental anguish, future mental anguish, past disfigurement, future disfigurement, past physical impairment, future physical impairment, past loss of enjoyment of life, future loss of enjoyment of life. And so this bill will reduce that to where it's only 4 blanks on the jury charge, past and future pain and suffering, past and future mental anguish, and then everything else goes into that. So we're looking at some pretty technical ideas that I hope will begin to make a bit of a difference in how these cases are tried in Texas.
Mm-hmm. There is no rational objection to providing clarity to the jury.
Right.
The jurors are not lawyers. Rarely does a lawyer get on a jury, and they don't understand what's going on. They don't know what happened. They walk into a jury room and they swear to do what's right, and they can be confused. And if our jury charges, because the definitions and the number of blanks are confusing, then you can't blame the jury for getting it wrong, because what we gave them was confused in the first place. Right. In some instances, generally the pattern jury charge is pretty good, but there are some issues with it. Additionally, it raises constitutional questions if there's a lack of clarity. I'll take a brief moment to just kind of recap the
Please.
90s.
Sure,
Yeah.
the 90s.
Yeah, go for it.
Usually we start with the Magna Carta, but if you want to start in the 90s, that's fine.
Well, so that I don't suggest that I'm dating myself excessively, I'll start in the 90s instead of a few centuries ago. In the 1990s, 80s and 90s, there was huge punitive damages awards that were 100 times, sometimes hundreds of times the amount of compensatory damages, and the U.S. Supreme Court finally weighed in with BMW, with some other cases, and held that if there's not appropriate guidance for juries so that their awards of punitive damages are not arbitrary guesses, but they have guideposts, then states are violating the due process clause of the Constitution because it's arbitrary. The findings are arbitrary. The states must provide guidance. Texas passed statutes that provide guidance. Other states did too. One of my colleagues and I've talked about this, and our view is that the situation with non-economic or soft damages in Texas and other states, without additional reforms, including legislation and common law guidance from the courts, that non-economic damages is about the same situation that punitive damages were in the 90s. There's an absence of sufficient guidance. The awards for soft damages are like the jury's picking fruit off a tree. They're arbitrary, and if they're arbitrary, then that is the touchstone for a violation of the due process clause of the Constitution. There's in the U.S. Supreme Court case law, there's quotes and statements that compare the necessity for reasonable guidance for compensatory damages with the necessity for doing so with punitive damages. And that comes from the case law in the 90s. So non-economic damages are in the situation, in my opinion, that punitive damages were in the 90s, calling out for guidance. Otherwise, we're going to be violating the Constitution.
Well, that's a
Wow.
great way to put our bill into context. It just really is the perfect way to do it, because that's what the bill is doing. Senate Bill 30 is creating some standards, creating some guidance that makes it not simply arbitrary. If the jury is not even given a definition of pain and suffering, how on earth can they know whether to award damages for pain and suffering? So for the statute to say, here's your definition and every court in the state must use it, is not disadvantageous to anyone. It is simply to give the jury guidance in order to make a decision, which, as you're pointing out, may in fact be a constitutional requirement.
Absolutely. I agree. Everybody benefits when there's some clarity, and we get proof of liability, proof of damages, and reasonable damage awards. Or if there's no proof of liability or damages, there should not be an award against the defendant. And anybody who's ever been a defendant realizes that should be the case.
Well, I don't want to end this too soon, but I want to just say that
Oh,
the bill we're working on, not a helmet, not a hat,
Oh, you've outdone yourself.
it's not a cap. It is none of those things. It is an attempt to do just as you described, to give juries some ability to make a rational decision about how to award non-economic damages. And I think that's a pretty good place for us to be in the legislature, and I hope we've got good support in the Capitol when the bill comes up for vote in the House and Senate in the next few weeks.
I'm all in favor of clarity and reasonable outcomes.
Good. Mary, what do you got?
I just no words. No words. That's a wrap. Thanks for joining us today. Everyone, Justice, thank you for coming. We really enjoyed it. I learned so much. I'm serious. It's so informative. Thank you. Happy Easter. We'll see you guys soon. Thank you.